this one, we are discussing chapter number 4, that is inspection, inquiry and investigation. तो below all जो है indicates the reason for such inspection by the concerned registrar of company. Since no information or explanation was furnished by company, since registrar of company on an examination of the documents furnished by the Sundry Cosmetic Limited, since registrar of company on an examination of document furnished by the Surrender Cosmetic Limited was of the opinion that the information or explanation furnished by the company was inadequate. Since registrar of a company was satisfied on a scrutiny of the document furnished by the sender by this Cosmetic Limited that an unsatisfactory state of affair existed in the company and the information and documents so furnished did not disclose a full and fair statement of information required. उसके बाद आ रहा है हमारा as per section 206 where the central government is of the opinion that it is necessary to investigate into the affairs of the company on receipt of report under section 208 intimation of the special resolution passed by the company that affairs ought to be investigated and public interest it may order an investigation that is not mandatory. So as per section 206 सेक्शन 206 क्या बोलता है? Where the central government is the opinion, सेंट्रल गवर्नमेंट की ये ओपिनियन है that it is necessary है इन्वेस्टिगेट करना into the affairs of the company on receipt of report under section 208 intimation of special resolution passed by the company that the affairs ought to be investigated and the public interest it may order an investigation which is not mandatory. For imposition of restriction on security application under section 222 shall be made to NCLT not to the central government. For imposition of restriction on security application under section 222 shall be made दी जाएगी NCLT को not to the central government. For imposition of restriction on security application under section 222 shall be made की जाएगी to whom? To the NCLT that is not to the central government. As per section 223, if any company is liable to be wound up under this act and it appears to the central government from any such report under section 223 that it is expedient so to do, the central government may cause to be presented to the tribunal. A petition for wind up of the company and PC on the ground that it is just and equitable that it should be wound up and an application under section 241 or both are the correct option. As per section 223, as per section 223, if the company is liable to be wound up under this act, अगर कंपनी जो है वो लाइबल है that is to be liable to be wound up under this act and it appears to the central government from any such report under section 223 that it is expedient so to do, the central government goes to be presented to the tribunal. A petition for wound up of the company BC on the ground that it is just and equitable that it should be wound up, an application under section 241 and both are the correct options. Then आता है हमारा as per section 206. As per section 206, where such information relates to any past period, the officer who had been in the employment of the company for such a period, if so called upon by the registrar, through a written notice, shall also furnish such information and explanation to the best of their knowledge. सेक्शन 206 बोलता है वह सच इंफॉर्मेशन रिलेट्स टू एनी पास्ट पीरियड से रिलेट करती है जो भी ऑफिसर होगा हु हैड बीन इन एम्प्लॉयमेंट ऑफ द कंपनी फॉर सच अ पीरियड इट कॉल्ड बाय द रजिस्ट्रार थ्रू अ रिटन नोटिस शैल आल्सो फर्निश सच इंफॉर्मेशन एंड एक्सप्लेनेशन टू द बेस्ट ऑफ देयर नॉलेज. Where the central government is of the opinion that it is necessary here to investigate into the affairs of a company by the SFIO, inter alia on intimation of the special resolution passed by a company, that its affairs are required to be investigated, it may by order assign the investigation to SFIO. Where the central government is of the opinion that it is necessary है investigate करना into the affairs of a company by the SFIO, inter alia on intimation of the special resolution passed by the company कि जो भी affairs है that the same are required to be investigated, it may by order assign the investigation to SFIO. So central government को ये लगे कि investigation करना जरूरी है by the SFIO inter alia on intimation of the special resolution passed by a company जो भी affairs है that the same are required to be investigated, it may by order assign the investigation to SFIO. As per section 206 whether such information relates to any past period से relate करती है, जो भी officer है who had been in employment of the company for such a period, if so called upon by the registrar through a written notice, shall also furnish such information and explanation to the best of their knowledge. जहां हमें लगता है where the central government is of the opinion that it is necessary to investigate into the affairs of the company, where the central government is of the opinion that necessary है to investigate into the affairs of the company by the SFIO inter alia on intimation of the special resolution passed by the company, कि जो भी affairs है that are required to be investigated, it may by order assign करेगा investigation to the SFIO. As per section 206 where such information relates to any past period, the officer who had been in employment of the company for such a period, if so called upon by the registrar through a written notice, shall also furnish such information and explanation to the best of their knowledge. As per section 206 where such information relates to any past period, जो भी officer होंगे who in the employment of the company for such a period, if so called upon by the registrar through a written notice, shall also furnish such information and explanation to the best of their knowledge. As per section 209, search and seizure can be undertaken by ROC only after the prior approval of the special court. Section 209 बोलता है कि search और seizure जो है that the same can be undertaken by ROC only after the prior approval of the special court. Seizure of books by ROC upon information in his possession or someone complain about the company. Seizure of books by ROC upon information in his possession or someone complain about the company under section 209 required चाहिएगा order from the special court. अगर information in his possession or someone complain about the company under section 209, how there will be the seizure of books by ROC. Seizure of books by ROC के upon information in his possession or someone complained about the companies under section 209, there will be required हमें क्या चाहिए होगा order from the special court. Order चाहिए होगा from the special court. How there will be the seizure of books by ROC upon information in his possession or someone complain about the company under section 209. It will require the order from the special court. In the course of investigation under section 220, no approval, कोई approval की जरूरत नहीं होगी. To investigate the affairs of the subsidiary company, CG approval is required under section 219. CG की approval चाहिए कि under section 219. The shareholder of a company after passing a special resolution at the general meeting, having a right to make an application to the central government for conducting an investigation into the affairs of the company under section 210 of the Companies Act 2013. जो भी शेयर होल्डर्स होंगे ऑफ अ कंपनी आफ्टर पासिंग जब भी वो स्पेशल रेजोल्यूशन पास करेंगे at the general meeting having a right to make an application to the central government for conducting an investigation into the affairs of a company under section 210 of the Companies Act 2013. As per section 218, a company cannot reduce the rank of employee during the period when investigation is continuing without seeking the approval of NCLT. Application to be disposed by the NCLT in 30 days. Application of the NCLT to be disposed होगी in 30 days. As per section 208, जो भी इंस्पेक्टर रिपोर्ट हो that the same shall be submit होगी सेंट्रल गवर्नमेंट को. It may include the recommendation for further investigation supported with the reason thereof. That the company can impose restriction on the transfer of shares of the company and make an application to the national NCLT under section 222. इन्वेस्टिगेटर जो है वो प्रोसीड कर सकता है to investigation of the affairs of the subsidiary after obtaining the prior approval of the central government. SFIO जो है वो submit करेगा report to the central government. Where the registrar के पास अगर reasonable ground है to believe that the books and the papers of a company are likely to be destroyed, mutilated, altered, falsified or secret, he may, after obtaining an order from the special court से order लेके of the seizure of such a books and a paper, seize such a books and a paper as he considered necessary. Whistleblower is not the ground for central government to make an investigation into the affairs of the company. Inspection, inquiry and investigation. हम क्या बोलते हैं that how there will be the inspection, inquiry and investigation. Inspection, inquiry and investigation क्या होता है? तो this will be the उसके बाद हम नेक्स्ट पढ़ते हैं compromise arrangement and amalgamation. Company shall not be disposed of without the prior approval of the central government. What is the compromise arrangement and amalgamation किस बारे में बात करता है? सेक्शन 239 जो है बुक्स ऑफ अमलगमेटेड कंपनी shall not dispose of without the prior approval of the central government. सेक्शन 239 जो है बुक्स ऑफ अमलगमेटेड कंपनी जो भी होगी that the same shall not be disposed of नहीं होगी, that the same shall not be disposed of without the prior approval of the central government. In the scheme of compromise or arrangement, section 230, sectorial regulator shall make representation within 30 days of receipt of such notice. In the scheme of compromise or arrangement वाली जो scheme है, that the same scheme, sectorial regular shall make representation करेगा within how many days? Within 30 days of receipt of such notice. For scheme of compromise or arrangement, both below requirement need to be fulfilled. Shall be approved by more than 50% majority, shall be approved by more than 50% majority in number of members or class of members. Creditor or class of creditor as the case may be who are present in voting at the meeting. Be approved by more than 75 majority in value or members or class of members or creditor or class of creditor as the case may be who are present in voting at the meeting. Purchase of share by minority sum received by transferor company shall be dispersed to the entitled shareholder within 60 days of such a receipt, that is via the separate bank account. So as per section 239, books of amalgamated company shall be disposed of without the prior approval of the central government. Section 239 बोलता है कि जो भी books होगी amalgamated company, that the same shall be disposed of without the prior approval of the central government. सेक्शन 239 क्या बोलता है कि जो भी बुक्स होगी अमलगमेटेड कंपनी की, दैट द सेम शैल बी डिस्पोज होगी विदाउट द प्रायर अप्रूवल ऑफ द सेंट्रल गवर्नमेंट. In the scheme of compromise or arrangement, both below the requirement need to be fulfilled. That the same shall be approved by the more than 50% majority number of members or class of members, creditor or class of creditor as the case may be, who are present and voting at the meeting. Be approved by more than, हम क्या बोलते हैं, for the scheme of compromise and arrangement. जो स्कीम होगी कॉम्प्रोमाइज और अरेंजमेंट बोथ बिलो द रिक्वायरमेंट दैट नीड टू बी फुलफिल shall be approval by more than approve होगा by more than 50% majority number of member or class of member, creditor or class of creditor as the case may be, who are present and voting at the meeting. Be approved होगा more than 75% majority in value of members or class of members or creditor or class of creditor as the case may be or are present and voting at the meeting. Purchase of share by minority sum received by the transferor company shall be dispersed होगा to be entitled shareholder within the 60 days of such receipt via the separate bank account. In compromise arrangement, no creditor meeting is required. Compromise और arrangement में कोई भी creditor meeting जो है वो required नहीं है अगर 90% of creditor in value confirms कर दे to it. In respect of a scheme of compromise submitted by the Neon Color Print Limited to the jurisdiction National Company Law Tribunal, that is the NCLT. A meeting of the shareholder was held on the specified date and time at the designated place. The company has 1200 shareholder and holding equity shares 1 crore 20 lakh, 12 lakh equity shares of rupees 10 each, who all voted using the prescribed means. However, 100 shareholder holding the 36,000 worth of shares voted against the approval of the scheme of compromise. Choose the correct option from those stated below as to whether the scheme of compromise submitted by the Neon Color Print Limited to jurisdictional National Company Law Tribunal is to be considered as approved or not. So scheme of compromise submitted by the Neon Color Print Limited to the jurisdictional National Company Law Tribunal is not to be considered as approved by the shareholder. That the same is not to be considered as approved by the shareholder. जो भी सेंट्रल गवर्नमेंट है that the same can file an application before the National Company Law Tribunal stating its objection that merger of company is not in public interest. जो भी सेंट्रल गवर्नमेंट है that the same can file an application before the National Company Law Tribunal stating its objection that merger of company is not in public interest. उसके बाद मर्जर जो भी होगा फॉर कंपनीज, हम क्या बोलते हैं मर्जर फॉर कंपनीज अंडर सेक्शन 233. फास्ट ट्रैक मर्जर इज ऑप्शनल इन नेचर एंड नॉट मैंडेटरी. Merger for company under section 233. Fast track merger optional है in nature and not mandatory. As per section 232, every company in relation to which the order under section 232 is made shall all cause a certified copy of order to be filed with ROC for registration within 30 days of receipt of the order. As per section, हम क्या बोलते हैं with section as per section 232, every company in relation to which the order under section 232 is made shall cause a certified copy of order to be filed with ROC for the registration within 30 days of receipt of the order. अगर हमें कैलकुलेट करना हो majority numbers and 75% of value under section 230, only members who voted shall be taken into consideration. 100 members and 20 did not vote, then the calculate majority, the 75% of 80 members. 75 compromise arrangement shall be approved by majority of person representing the 3/4 in value to the aggregate SCA present and voting. जो भी एक्वायरर, हम क्या बोले, जो भी एक्वायरर पर्सन और ग्रुप ऑफ पर्सन अंडर सेक्शन 236 सबसेक्शन 1 shall offer to the minority shareholders of the company for buying the equity shares held by such shareholders at a price determined on the basis of valuation by the registered value or not the chartered accountant. उसके बाद आता है हमारा विनायक फार्मास्यूटिकल कंपनीज लिमिटेड डिसाइडेड टू अमलगमेट द सुपर मेडिसिन लिमिटेड एंड अकॉर्डिंगली an application for amalgamation was submitted to the jurisdictional national company law tribunal. If the tribunal is satisfied that the specified procedure has been complied with, it may by order and sanction the scheme of arrangement leading to the amalgamation and make the provision for various matters. From the following options, choose the one which may find place in the order of arrangement leading to application made by the tribunal. Super Medicine Limited shall be dissolved without the winding up. That is section refers section 232. Then आता है हमारा in case of listed company takeover shall be as per the regulation framed by the SEBI. Referred listed company के जो भी frame SEBI ने regulate किया and all such thing. A compromise or arrangement may be between, हो सकता है between the company and its creditor, not between the company and its debtors, company and its officer. It is between. Compromise arrangement में भी किसके बीच में होगा? Company and its creditors के बीच में. The book papers of a company which has been amalgamated with those whose shares have been acquired by another company under chapter 15 shall not dispose or without the prior permission of the central government. जो भी स्पेसिफिक स्ट्रेंथ होगी क्रेडिटर की इन वैल्यू ऑफ दिस एम्बार्क फूड प्रोडक्ट लिमिटेड एग्री टू द स्कीम ऑफ कॉम्प्रोमाइज विद द कंपनी प्रपोज एंड अकॉर्डिंगली द सेड स्कीम वाज फाइल्ड विद द jurisdictional tribunal in order the tribunal may not call a meeting of creditor by filing which document the creditor need to indicate their intention to tribunal they agree and conform to the scheme of compromise by signing an affidavit which indicate that they agreed to not calling a meeting. A scheme of compromise was submitted by SP Cement Limited to the National Company Law Tribunal. Meeting of shareholder was held on the specified date and time and at the designated place. The company has 1200 shareholder holding equity shares of 1 crore 20 lakh equity shares of this, who all voted using the prescribed modes. However, 100 shareholder holding the 36 lakh worth of shares voted against approval of a scheme of compromise. Choose the correct legal position with respect to the said scheme in the given situation. The scheme of compromise is not approved. नहीं होगी section 230 तो section 6. उसके बाद जो भी स्कीम है compromise is approved since shareholders holding more than 60% worth of shares in a value voted in favor of the scheme. Then आता है prevention, operation and mismanagement. Then comes the prevention, operation and mismanagement. Failure to declare dividend raise does not amount to operation. अगर dividend नहीं दिया इसका मतलब नहीं है कि operation हो गया. No, this is not the case. Majority shareholder passed this special resolution to alter the AOA and empower the BOD to transfer the share of any shareholder who competes with the business of the company. Both below the options are correct. Alteration हुआ है article of association में is valid and not operation since the article are being altered after the following process of law. Alteration of article of association is valid, not operation since the articles are being altered in the interest of the company. As per section 244, application shall be made in case of a company having the share capital which is not less than 100 member or 1/10 of the total member, whichever is less. As per section 244 ये बोलता है कि it is to be made in case of a company having share capital not less than 100 members or 1/10 of the total number of members, whichever is less, members holding not less than 1/10 of the issue share capital of the company. The legal heir is entitled to file a petition under section 241 if any person is not eligible to apply under section 244, but after his death his legal heir can make an application to tribunal. कंपनी फेल हो जाएगी to comply with the order of NCLT, fine 1 lakh to rupees 25 lakh. A majority shareholders representing himself as the managing director of the company, although not formally appointed as a managing director, is not an act of operation. Mr. Derek Jonathan, a majority shareholder, represented himself with the managing director of this Ceramics Limited and also discharged the functions in the capacity of its managing director. However, he was not formally appointed as managing director of this Ceramics. A group of 6 members holding 1/12 of the issue capital, which amounted to 1/10 of the paid-up share capital of the company, filed an application with the NCLT National Company Law Tribunal, claiming that such an act of Derek Jonathan constituted the operation. The total number of members of this of 72, the group of 6 members cannot file an application with the National Company Law Tribunal since the given fact patent does not constitute the operation. ABC Limited is a company which is limited by share, उसके 700 member है. For an application under section 241 relating to the relief in case of operation, the minimum members required to make an application before the tribunal is at least 70 member, यानी कि 1/10 of the members और 100 members, 1/10 और member whichever is over होता है तो 70 member हो गया. उसके बाद एनी कंपनी, उसके बाद आएगा हमारा एनी मेंबर ऑफ अ कंपनी हु कंप्लेन दैट द अफेयर्स ऑफ द कंपनी आर बीइंग कंडक्टेड इन अ मैनर टू जुडिशियल हेड टू द पब्लिक इंटरेस्ट, तो वो क्या करेगा, ट्रिब्यूनल को बोल देगा फॉर रिलीफ इन केस ऑफ ऑपरेशन. Class action as specified in section 245 of the Companies Act shall not be applicable on a banking company. बैंकिंग कंपनी पे एप्लीकेबल नहीं होगा. नॉट इंश्योरेंस, एनबीएफसी एंड दिस नॉट एप्लीकेबल टू बैंकिंग कंपनी. देन कम्स द वाइंडिंग अप. वाइंडिंग अप क्या बोलता है, व्हाट डज द वाइंडिंग अप टेल्स टू अस. जो भी लिक्विडेटर होगा वो सबमिट करेगा हिज रिपोर्ट टू द ट्रिब्यूनल विद इन 60 डेज फ्रॉम द डेट ऑफ वाइंडिंग अप ऑर्डर. लिक्विडेटर जो है वो सबमिट करेगा अपनी रिपोर्ट ट्रिब्यूनल को विद इन 60 डेज फॉर द वाइंडिंग अप ऑर्डर के लिए. Order for the winding up of a company shall operate in a favor of all the contributories and the creditors of the company. जो भी order होगा winding up का, that the same shall be operate होगा in the favor of all the contributories and the creditors of the company. Liquidator has a shareholding of a company. He can be appointed in X Limited by disclosing his shareholding by filing of declaration within 7 days from the date of his appointment by the tribunal. उसके बाद स्टेट विच अमंग्स द फॉलोइंग ग्राउंड्स इज इनकरेक्ट फॉर द रिमूवल ऑफ द प्रोविजनल लिक्विडेटर ऑफ अ कंपनी, लिक्विडेटर एज लिक्विडेटर ऑफ द कंपनी. इंडिपेंडेंट वर्किंग हैविंग नो conflict of interest, this is not valid ground. Professional incompetencies or failure to exercise due care and diligence in performance of powers and function, misconduct and fraud or misfeasance. जो भी periodical report है made by the company liquidator to the tribunal with respect to the progress of winding up to be submitted at the end of each quarter may be reviewed by tribunal on the application by the company liquidator. जो भी periodical report होगी which is made by the company liquidator to the tribunal with respect to the progress of winding up to be submitted at the end of each quarter may be reviewed by the tribunal on an application by the company liquidator. Where the winding up order has been made to all the property and effects of the company, it shall be deemed in the custody of the tribunal from the date of order of the winding up of the company. 5 consecutive years a company may, on the petition under section 272, be wound up by the tribunal if the company has made a default in filing with the registrar its financial statement or annual returns for immediately preceding 5 consecutive financial years. A petition to the tribunal for the winding up of a company can be presented by the chief executive officer, can be presented by the company registrar or contributory. Then आता है हमारा 9th one. If the registrar intends to file a petition for the winding up of a company, how shall he proceed? The registrar shall obtain previous approval of the central government. Registrar जो है वो obtain करेगा previous approval of the central government. अगर registrar चाहता है file a petition for winding up of a company, how shall he proceed? He shall obtain करेगा previous approval of the central government. ROC जो है previous approval of central government ले लेगा. Saurabh, after winding up the affairs of the Shobna Plastic Limited in the capacity of company liquidator, made an application to the jurisdictional National Company Law Tribunal for its dissolution. Taking the note of dissolution application, NCLT proceeded to make an order that Shobna Plastic Limited be dissolved from the date of order. From the given option, choose the one that will be applicable in the given situation. Within the period of 30 days from the date of the order, NCLT shall forward a copy of the order to the registrar and also direct the Saurabh to forward the copy of order to the registrar. जहाँ पे petition जो है present हुई on the ground that it is dash that the company should be wound up, the tribunal may refuse to make an order of winding up. It is of the opinion that someone other remedy is available to the petitioners and they are acting unreasonably in seeking to have the company wound up instead of pursuing the other remedy. Just and equitable, not just and appropriate. It is what? Just and equitable. Where the winding up order has been made to all the property and effects of the company that shall be deemed to be the custody of the tribunal from the date of the order for the winding up of the company, who cannot make a petition to the tribunal for the winding up of a company, that is the independent director. The company liquidator जो है that the same shall be appointed by dash from among the insolvency profession registered under the Insolvency and Bankruptcy Code 2016. The tribunal, not the registrar of the company. ABC Limited not dissolve नहीं होगा on January 1, 2020. After 2 years on January 1, 2023, the company creditor Mr. Patel applies to the tribunal to declare the dissolution void. Mr. Patel had an outstanding amount of 1 crore owned by the ABC Limited. However, before the dissolution of ABC Limited, the company write off the outstanding amount in its books of account. Suggest your opinion, but what will be the tribunal do as per the provision of the Companies Act 2013 from amongst the requirement given? The tribunal will make an order declaring the dissolution to be void. Ask the liquidator to forward a copy of the order within 13 days from the date thereof to the registrar, who shall record the same. Certified copy of the said order is to be filed by Mr. Patel, and the tribunal was not grant the application. Choose the correct option. That is only 4. The tribunal will not grant the application. देन आता है हमारा द चैप्टर दैट इज द मिसलेनियस प्रोविजन. मिसलेनियस प्रोविजन के अंदर हमें क्या क्या दिया है और किन किन बातों का डिस्कशन हम करने वाले हैं. ए लिमिटेड जो है अमलगमेटेड हो गई है इनटू द एबी लिमिटेड. द लेटर कंपनी एबी लिमिटेड हैड held 100% shares in AC Limited. Both AB Limited and AC Limited had 10,000 shares in A Limited before the amalgamation took place. A Limited had a total 1 lakh issue shares before amalgamation and 70,000 shares therein were held by B Limited, which also later became shareholder of AB Limited under amalgamation. But the shareholder apart from B Limited and excluding AB Limited and AC Limited holding the 10,000 share did not become the shareholder in the new AB Limited, assuming all the other conditions of amalgamation and the nature of merger are fulfilled. Would this be? One of the conditions that is at least 90% of shareholder of transferor company becomes the shareholder of the transferee company. To calculate 90%, exclude the share held by the transferee and transferee subsidiary company. 90% of this, that will be the which is more than 70,000, 90% criteria not fulfilled. So it's amalgamation in the nature of purchase, not the merger. It is the amalgamation in the nature of merger. Merger है not it's the nature of purchase, not the merger. B Real Estate Developers Limited was demerged to B Realty Construction and Developers Limited, and B it is the partial demerger. B Real Estate Developers Limited was demerged हो गई to B Real Construction and Developer Limited, and it is the partial demerger. Foreign company shall within 30 days of establishment of principal place of business in India deliver the requisite document to the specified authority. 30 दिन में दे देगी. Penalty to foreign company for failure to deliver the document within the prescribed period. Section 392 लगेगा 1 लाख से 3 लाख की penalty और 50,000 per day for committing containing offence के लिए. Radix Healthcare out of India company has online presence in India, not a foreign company, and it has no place of business established in India. ICI answer seem to be incorrect. Okay. For declaration under section 380, that is none of the director authorized representative is debarred from formation of company. Declaration from all the directors and authorized representative, that is not secretary. A company incorporated in India cannot be considered as a foreign company merely because it is a wholly owned subsidiary of a foreign company. Foreign company have to file the financial statement within 6 months from the close of the financial year. If the foreign company is incorporated for more than 2 years, even then it is required to mention the following prospectus, that is date and signature on prospectus, the date and country of incorporation. If company has a principal place of business in India, then its address, and what are the matters specified under section 26. What will be the dormant company not filed a financial statement or annual return for 2 consecutive years? Not filed the financial statement and annual return for 2 consecutive years. An employee is not competent to file complaint before the special court for illegal issue or transfer of security. Only person authorized by SEBI is empowered. सिर्फ जिन लोगों को SEBI empower करेगा वही लोग कर सकते हैं. NCLT is empowered to refer suo motu any matter proceeding to the mediation and conciliation panel. As per section 439 के according, every officer is a known compoundable and known cognizable offence except 212. If any punishment there and between imprisonment and a fine, it shall not be known compoundable offence. Since it is known compoundable, it shall be known cognizable offence. Tribunal within 2 years amend its order for mistake apparent from record suo motu or on application. If the company defaults on its financial statement or annual return for immediately preceding 5 consecutive years, the tribunal may by order winding up on a petition filed by the registrar. Foreign company is required to submit various documents to ROC New Delhi, ROC having jurisdiction over company's principal place of business. Nidhi Limited Company Incorporated cannot issue the preference shares. Application for the restoration of the company, any person aggrieved by order of the registrar within the 3 years from the date of passing of the order dissolving the company. जो भी registered value होगा, within how many days authority will grant the certificate of registration to the applicant, carry on the activity of a registered value within 60 days of receipt of the application, excluding the time given by the authority for presenting the additional document, information or clarification or appearing in the person as a case may be. Workmen जो है eligible है to file an application for restoration of name of the company in the registered company, but before the expiry of 20 years of the notice from the publication in the official gazette. एज पर द निधि रूल 2014, निधि कंपनी जो है वो एक्वायर कर सकती है और परचेज कर सकती है सिक्योरिटी और एनी अदर कंपनी और कंट्रोल द कंपोजिशन ऑफ द बोर्ड ऑफ डायरेक्टर और एनी अदर कंपनी इन एनी मैनर व्हाटसोएवर एंटर इनटू एनी अरेंजमेंट फॉर द चेंज ऑफ इट्स मैनेजमेंट. Any person aggrieved by an order made by the adjudicating officer for adjudicating penalty may refer an appeal to having jurisdiction in the matter of the regional director, not the appellant tribunal, refers section 454 of the Companies Act. Jitendra, Jyoti, Lovely, Jasprit, Satwinder, Mahinder thought of uplifting the lower and a middle income group persons of Sangrur district in Punjab, which lead to the formation of Nanak Treasurer Nidhi Limited on this. In this, with an authorized capital of 50 lakh and paid up capital of 7 lakh, having a good response from the local resident, after the 3 months of its incorporation, Nanak Treasurer Nidhi Limited persuaded 270 more members to join the Nidhi company. By the end of 6 months, it had an addition of 64 members. At the end of 10 months, 98 more members joined. No new members joined in the last 2 months. How many excess members of Nanak Treasurer Nidhi Limited had in comparison to the minimum required on 21st September 2021? Nanak Treasurer Nidhi Limited had 239 excess members in comparison of the minimum required of Nidhi rule 239. Then comes Save Money Nidhi Limited was incorporated on 2nd May 2022 by the Raghuveer, his 6 close relative and members in Meerut, Uttar Pradesh, with a view to provide financial help to lower and middle income groups. After his incorporation, the company is required to apply to the specified authority for declaring it as a Nidhi maximum within how many days of its incorporation. Save Money Nidhi Limited should proceed to in this respect maximum within 120 days of its incorporation. After having registered their company, Jwala Saving Nidhi Limited with jurisdictional registrar of company Gwalior MP this on July 1st, 2022. All the promoter being resident of Chindwara are interested in getting declared their company as a Nidhi. From the following option, choose the one which indicate the authority that will grant Jwala Saving Nidhi Limited the status of Nidhi if all the formalities are committed. जो भी सेंट्रल गवर्नमेंट होगा is the authority which will grant Jwala Saving Nidhi Limited the status of the Nidhi if all the formalities are completed. For declaring itself as a Nidhi company, Nidhi Limited shall apply to the specified authority maximum within a period of 120 days from the date of its incorporation. Bhalu Paisa Nidhi Limited, incorporated by Biswas Joy and Salil in a Bankurura district of West Bengal on 7 June 2021. To inculcate saving habit in their community had 50 members at the time of incorporation. It is very well known to them that the members has to be increased to the specified number, but they are not sure about the maximum time limit for increase. You are required to advise them by choosing the appropriate option from those given below. Maximum by the end of 1 year from 7 June 2021, the membership must be increased to the specified number. Suhail, Tripathi, Suresh Khanna and their close association numbering 12 incorporated a joint stock company with an authorized capital of 25 lakh, which is divided 2 lakh 50,000 equity share of rupees 10 each, and paid up capital is 14 lakh. On 4th May, the company is now in the process of finalizing the subsequent legal procedure for its notification in the official gazette by the central government. Which kind of companies Suhail Tripathi, Suresh Khanna and their close associates are intending to form? They want to form a Nidhi company. They want to form a Nidhi company. Dormant company, हम क्या बोलते हैं? Dormant company, a company is formed and registered under the Companies Act 2013 for a future project or to hold an asset or intellectual property has no significant transaction. Such a company may make an application to the registrar. जो भी सेंट्रल गवर्नमेंट है they propose to issue the notification which provided the certain provision of the Companies Act 2013 either shall not apply or shall apply with such exception and modification as may be specified in the said notification. It is required that the draft copy of such a proposed notification shall be laid before each House of Parliament while it is in session. From the following four options, choose the one which correctly indicate the total period for which the proposed notification shall be laid before each House of Parliament. जो भी proposed notification होगा that shall be laid before each House of Parliament for a total period of for a total period of 30 days. फिर आते हैं हम कृष्णाकांत, सूर्यकांत and other person known to them from the close quarters formed Gopala Money Nidhi Limited with a paid up capital of 20 lakh in Gujarat. Choose the correct option from those below that indicate the nature of activity in which the Gopala Money Nidhi Limited would be involved. Gopala Money Nidhi Limited was formed with the object of cultivating the habit of thrift and saving amongst its members. Gopala Money Nidhi Limited was formed with the object of receiving deposit from its member only. Gopala Money Nidhi Limited was formed with the object of lending money to its member only, and all of the above. The answer is all of the above. Gopala Money Nidhi Limited was formed with the object of cultivating the habit of thrift and saving among its members. Gopala Money Nidhi Limited was formed with the object of receiving deposit from its member only. Gopala Money Limited was formed with the object of lending money to its member. The answer is all of the above. The gain by unlawful means of property to which the person gaining is not legally entitled is called as wrongful gain. Rajpal, Satpal, Gopal, Mahipal and another 196% of Ambala district of Haryana incorporated a Nidhi company under the name Great Saving Nidhi Limited on 22nd April 2022. From the following options, select the correct one as a reason for its incorporation. Great Saving Nidhi Limited was formed with the object of cultivating the habit of thrift and saving among its members, receiving the deposit from and lending to its member only for the mutual benefit. उसके बाद आ रहा है हमारा Mr. Hai with his friend and relative incorporated a Nidhi company under the name Dhan Lakshmi Limited. On 20 August 2017, as on 31st March 2023, the paid-up share capital of Dhan Lakshmi Limited Incorporated was 95 lakh. 9,50,000 equity shares of rupees 10 जो भी deposit है worth to the extent of 315 crore with the 12,000 members. जो भी loan aggregated होगा to rupees 275 crore. Keeping in view the sufficiency of profit, the company declared a dividend of 1 rupee 1 per share. Requirement enumerate how much the excess paid-up share capital of Dhan Lakshmi Limited had when it started its operation in 2017 and what shall be the maximum amount of dividend that Dhan Lakshmi can declare for the financial year 22-23. तो हम क्या बोलते हैं धन लक्ष्मी लिमिटेड हैड एक्सेस पेड अप शेयर कैपिटल है 85 लाख की व्हेन इट स्टार्टेड इट्स ऑपरेशन कैन डिक्लेयर द मैक्सिमम परमिटेड डिविडेंड ऑफ 2.50 पैसे पर शेयर 2.50 2.50 में Dhan Bhandar Nidhi Limited, having the registered office in Gorakhpur district of Uttar Pradesh, is applying to the specified authority for declaration as a Nidhi company. It is required to take the declaration along with the application with regard to the fulfillment to fit and proper person criteria for the three directors, namely Lalit, Sohan and Vikas. Choose a suitable option from those stated below as with attributes of director, ignoring the various disqualification are considered for fulfilling fit and proper person criteria. जो भी इंटीग्रिटी होगी ललित, सोहन एंड विकास हु आर डायरेक्टर ऑफ धन भंडार निधि लिमिटेड. Honesty, ethical behavior and reputation of Lalit, Sohan and Vikas, who are director of Dhan Bhandar Nidhi Limited. Fairness and character of Lalit, Sohan and Vikas, who are director of Dhan Bhandar Nidhi Limited. All of the above. The correct answer is all of the above. Unnati Nidhi Limited was incorporated on 5th April 2022. Initially had 100 members, but this number was short of minimum stipulated number of members. Maximum within how much time period this number of 100 members must be raised by adding new members so that the minimum stipulated number of members is attained by Unnati Limited. The minimum stipulated number of members must be achieved by Unnati Nidhi Limited within a period of 100 from the date of incorporation. Swastik and Pratibha of Ghana, Madhya Pradesh, along with their close friends, are planning to get a company registered with starting name as Swastik Pratibha. The company shall be the Nidhi company with the authorized capital of 20 lakh. Which of the following option is applicable in the given situation? The company shall be registered as Swastik Pratibha Nidhi Limited. The company shall be registered as Swastik Pratibha Nidhi Private Limited. Swarna Vikas Nidhi Limited has registered office in a Bindhan Nagar, West Bengal, with over 250 members. The company has filed an application in the prescribed form with the specified authority for its declaration as Nidhi status. Maximum within how many days the specified authority is required to convey its decision to Swarna Vikas Nidhi Limited, that is maximum within 45 days. Then आता हमारा adjudication, special courts, NCLT and ANCLATE. As per the Companies Act 2030 बोलता है every petition filed before the tribunal shall be disposed होगी within 3 months from the date of its presentation. It shall be within 3 months from the date of its petition. Trial of an offence under the Companies Act by special court shall be such offence which is punishable with imprisonment for a term not exceeding 3 years. जो भी agreed होंगे by NCLT order that will prefer the enclave appeal, prefer an appeal against the order passed by NCLT Mumbai within a period of 45 days from the order of copy made available to him. National Company Law Tribunal can amend its order to rectify any mistake apparent from the record when such a mistake is brought to its notice by the party, and further the order shall be amended by NCLT at any time within a period of 2 years from the date of such order, provided no appeal has been made against the said order. जितने भी offences is specified under section 435(1) shall be triable by the special court. It will be triable by the special court. जो भी NCLT है that shall not hear the appeals against the order of district order. जो भी offences होंगे where the complainant enter into a compromise and agree to have the charges dropped against the accused is called as the compoundable offences. Where a company having already been subjected to penalty for default under the provision of Companies Act 2013 again commits such a default within a period of 3 years from the date of order imposing such a penalty passed by the adjudicating officer, it shall be liable for the second or subsequent default for an amount equal to the twice the amount of penalty provided for such a default under the relevant provision of this act. So be provision of the Code of Criminal Procedure section that is 1973, that is not company, shall apply to the proceeding before a special court. Which of the following is non-compoundable offense? That is the penalty of fine only, the penalty of fine or imprisonment, penalty of imprisonment or fine or with both, and penalty of imprisonment only. Which of the following is non-compoundable offense? क्या है? Penalty of fine and imprisonment, penalty of fine, imprisonment दोनों. तो the correct answer is penalty of imprisonment only is a non-compoundable offense. Then coming to the next chapter, that is the e-filing. जो भी nomenclature है MCA 21 reflect करेगा that had MCA is capable of fulfilling the aspiration of its stakeholder in the 21st century. Electric form for the specified purpose shall be exclusive or in the alternate or in addition to the physical form. SRN stands for the service request number. That is what? That is the service request number. Required to file the financial statement through the XBRL if it had the paid up share capital of 5 crore and above. XBRL, that is extensible business reporting language. XBRL is nothing but the extensible business reporting language. इसके बाद जो other law वाला part है, that will we will make the separate video for it and discuss and do the plain reading, or for the retention purpose we will discuss in the next and subsequent one. Alright.